Hello, it's Philip Taylor speaking from Richmond Green Chambers, and this morning I'm looking at a book from Oxford University Press. It's in their series of books, it's this book here, it's in their series of books on Oxford Monographs in International Law. That's the front of the book, the side, and then the back. It's only a very light book, and it's called, as I say, The Margins of Appreciation in International Human Rights Law. It's got a subtitle, Deference and Proportionality, and it's been written by Andrew Legg. We've given it a title, Margin of Appreciation, a key yet controversial doctrine for international law. We'll have a look at the book in a minute, because the first question that has to be asked is, what do we mean by the margin of appreciation? Because when we're looking at human rights and the legal systems we have for human rights, the margin of appreciation really, as I understand it, is what parts of the human rights laws will be actually applicable in any particular member state that has the human right law. Now, that appears to me to be the position. What we say, though, is that the book itself is part of the Oxford Monographs in International Law series, published by OUP, and what they're doing is, with this particular work on margin of appreciation, they're adding the title to the growing OUP series, and they're looking at this subject as being noted as one of the most potent and interesting legal concepts to have emerged in international law in recent decades. Because what we're really looking at is, when you've got the international legal picture, you then have the member states, and the question really is how far they go down the human rights law route. So, in accordance with the aims of the series, this is an important and original piece of legal research from Legg into the nature and ramifications of this judicial doctrine, which allows individual member states to have some latitude in their interpretation of their own human rights treaty obligations, notably in our case, the European Convention on Human Rights. And as Legg provides here a very absorbing, in-depth analysis and defence of the doctrine in international human rights law itself, he admits that the margin of appreciation, as he calls it, is a controversial doctrine and not the easiest to grasp, and he points out that it is a doctrine of judicial deference and a common and appropriate feature of adjudication which lies at the heart of many of the most important international human rights cases. Ouch, we say. There's some more controversy here. We're not inordinately fond of such terms as judicial deference, but of course that's a personal view from us. However, if we interpret this correctly, it begs a number of questions, including one of whether judges can make decisions comparable to dissenting judgments and centred on the ability of an individual state to opt out of or ignore all or part of, for example, the Universal Declaration of Human Rights, on a particular matter, which would have some significance perhaps to their own culture. Now, there are plenty of other examples. This is the book itself. Do have a look at it. There's a general preface there. Then there are the contents pages there. The book itself, very useful abbreviations, and the book itself also has a lot of footnoting and a great deal of detail. I found it fascinating, and in this short review I cannot do that much justice to what is an intriguing area as we review human rights in the second decade of the 21st century. But thank you all for producing what is a great topic for further debate. Bye-bye.